Michael A. Gamboli is a partner at Partridge, Hahn LLP, the sponsor of this legal learning series. He advises and defends businesses on all aspects of employment law, partnering with business clients to strategically address employment issues in order to minimize the legal risk and impact on business operations. Mr. Gamboli works closely with human resource professionals, in-house counsel, and executives on a daily basis to provide strategic advice on legal compliance, wage and hour, employee discipline, leaves of absence, termination, and general employment issues. He has extensive employment litigation experience, having defended claims in multiple state and federal courts and before state and federal administrative agencies involving discrimination, wage and hour, harassment, and whistleblower retaliation, and the enforcement of non-competition agreements. He has been selected by his peers for inclusion in the Best Lawyers in America since 2010 and was named Best Lawyers Employment Lawyer of the Year in Rhode Island in both 2015 and 2018. Since 2009, he has been recognized as Band 1 Management Side Employment Attorney by Chambers USA and selected by his peers as a Rhode Island super lawyer. And he has also been recognized as a labor and employment star by Benchmark Litigation and is AV Preeminent rated by Martindale and Hubbell. Mr. Gamboli is a graduate of Bucknell University and a magna cum laude graduate of Boston University School of Law. Without further ado, I will pass it on to him.
Thank you. Thank you. Welcome, everybody. And we'll try to multitask a little bit. If you guys have questions, you're welcome to throw them into the chat. I don't even mind if you go off mute and ask a question. I'll try to do both, and we'll work our way through. So we have a decent amount to cover. You can jump to the next slide. So here's what I thought we'd do. We have an hour. We're going to hit a lot of different topics. We're probably not going to dive deep on any of these. When we were talking in prep, a lot of these slides, we could probably talk for an hour on each slide and each of the subtopics on the slides. But what we thought would be more beneficial for you folks would be to sort of go soup to nuts, cradle to grave, and hit a bunch of topics within hiring, within general policies, and then talk about some termination issues. So those are the three main ideas. So let's start off with the beginning, right? Which is what issues should we consider when we're bringing people on, onboarding and hiring? And the first issue is, what questions can I ask, or what questions to stay away from? So again, high level, don't ask any questions about protected characteristics, right? We all know how discrimination works and what the protected characteristics are. Don't ask questions about that. Keep it simple. Don't ask if you're a U.S. citizen. Don't ask about whether the person's married. Don't ask how old the person is. Don't ask if the person has a disability. Don't ask what the person's religion is. Don't ask if they've been arrested. Don't ask if they're a drug addict, right? All of those different characteristics are protected in one way or another, and it can be discriminatory to try to dive into those topics. So there are, from a question of age, right? I don't care how old you are, but if I'm concerned that because you're older, it's going to be hard for you to do this job because you'll be traveling 24/7, ask the person, is it okay to be traveling 24/7, right? If I have questions about a person's religion, I'm concerned about it. That's not the question to ask. The question to ask is, you're going to be working every Saturday and Sunday. Can you do it? All right. Ask about the job specific issues, not about a person's specific characteristics. In terms of offer letters, they're a good idea to have sort of a template or a form offer letter. It's not a contract. The question is what you want to put in there. You want to sort of lay out the ground rules for the engagement. The obvious things are, here's your position, here's your start date, here's your compensation, lay out benefits. You also want to include a number of things that are employer friendly, such as you're an employee at will, right? We can fire you for any reason or no reason. You can quit anytime. We just want to make that clear. And we want to make clear there's nothing anybody can say that can change that. You want to make sure that there's no restriction on the person's ability to work for you, depending on your particular organization. We just want to confirm that you're not under some sort of restrictive covenants agreement, a non-competition agreement, or something along those lines that would impact your ability to work for us. We'll talk a little bit. Go backwards. You jump the slide, I think. Yeah. If if you want the person to be under an arbitration agreement, we'll talk about that in a minute. You want to lay that out in the offer letter. If you want the person under some type of restrictive covenants agreement, you want to lay that out in the offer letter. If you're going to do a background check, let them know that the offer is conditioned upon them passing a satisfactory background check, either criminal history or credit. So offer letters make a lot of sense for those reasons. Some people think, I want to have an employment contract with a lot of different items in there. You almost never need an employment contract. Most of the time, what you're trying to accomplish can be accomplished with an offer letter and maybe a restrictive covenants agreement. So I would encourage you to get in the habit of using offer letters. They just make sense for a lot of different reasons, and it helps with consistency. We'll probably get to it at the end if we have time, but I would do the same thing on termination letters, right? You should have a template that when somebody leaves the organization, here are the 5 or 6 things that you need to know. Here's when your benefits end. Here's when your last payday is. Here are your obligations to us as a reminder. The sort of the basic information that you're going to want somebody to walk away with, especially at the termination stage. Because for those of us who've been through situations when you terminate somebody, once you tell them they're terminated, they're not listening to anything else you say. They're thinking about where my next paycheck's coming from. They're thinking about when my health care is going to end. So it's important, just as a matter of good business practice, to have a termination letter that lays out in a similar fashion the things we want to lay out in an offer letter. Arbitration agreements I touched on. Consider whether you want to have an arbitration agreement. They're not that complicated. It's basically an agreement between you and the employee that if you have any dispute, you're going to submit it to arbitration versus going to court. And there are pros and cons to when you want to use arbitration agreements, but sort of big picture from an employer standpoint, especially if you have a public-facing type organization, I think a lot of you do. The reasons to use arbitration agreements are versus a court fight, right? Is arbitration's quicker. Not necessarily quick, but it's a lot quicker than court. It's less expensive. Again, it's not inexpensive, but it's a lot less expensive than court. You avoid a jury when you go to arbitration, which in the employment context, you typically want to do. You typically do not want to be fighting with an employee in front of a jury, because the entire jury are typically employees. There are some things that can't be arbitrated, or they're optional: sexual harassment, sexual assault. There's federal law on that. It's up to the employee as to whether or not they want to arbitrate, but you can still have an arbitration agreement. You just can't force it. And there's also, if you're a bigger organization, when you have wage and hour type issues, a lot of times you may run into trouble because you misclassified a whole slew of people, or you mispaid a whole slew of people, and you'll get into a class action. Where a savvy plaintiff's lawyer will want a class action, because that's where they can actually make money, because each of the people in the class are not owed that much money. If you have an arbitration agreement, you can put a provision in it that says you are waiving your right to participate in a class. You are waiving your right to proceed as a representative, and you have to go individually. That will actually be enforceable. You can do that anyway. Pretty sketchy whether it's going to be enforceable or not outside the arbitration context, but generally arbitration agreements are governed by the Federal Arbitration Act. So anything you put in them is sort of Teflon and protected. So that's a big advantage. If you want, court, there are advantages to court. If it's a lousy case, you can get it thrown out in court more easily. That's not going to happen with an arbitration necessarily. And actually, sometimes arbitrations, the good news is it's fast, but sometimes from an employer standpoint, depending on the situation, it's too fast. There is some leverage from the employer's side if there is a dispute to say, let's see if we can resolve it in a quick fashion, because your other option, if you sue us, is going to be fighting us in court for 3 years. And that's not a great way to go. So there are pros and cons there, but overall, I tend to lean towards, from an employment standpoint, I think arbitration agreements make sense. Also, a big one for public-facing organizations is it's not public. Bits and pieces can become public, but as a general rule, everything in the arbitration agreement is in the arbitration setting is confidential and private, and nobody's going to know about it. Employment agreements, like I said, I've seen clients recently that are asking me to look at their employment agreement, and they have everybody, in the organization sign an employment agreement. That doesn't make a lot of sense. You almost never need an employment agreement. If it's an executive who you're paying severance to and you want to lay the severance out, that's when you need one. But from an employer standpoint, unless I'm paying somebody severance and I need to commit it to writing, I generally never need an employment agreement. The advantage to the employer is really, I'm going to put restrictive covenants in there, like, a non-competition agreement, a non-solicitation, a confidentiality. You can just do those separately. You don't need an entire employment agreement. And a lot of times, things in the employment agreement, like compensation, change in 6 months. So they become sort of outdated. And that jumps us to restrictive covenants. That's another thing to consider at the hiring stage is it a good idea for me to have some sort of restrictive covenants agreement? And by that, I mean either a non-disclosure, simple confidentiality agreement that you're going to keep everything about the company confidential, which I would encourage no matter what for everybody. And then there's a question of real restrictive covenants that when you leave the organization, you can't solicit our customers, you can't solicit our donor base, you're not going to compete with us in some way. So again, if you're going to put one of those in place, the time to do it is certainly at the commencement of employment. There are a lot more hurdles to jump over depending on what state you are in to try to do it with existing employees. Easily doable, but just a little bit more difficult than at the outset, and a little bit less enforceable. Because you can imagine the question is whether somebody entered into it voluntarily. Certainly at the commencement of employment, they can say yes or no. If they're in the middle of the employment, courts look at that a little bit more askance, right? Like they didn't really have that great of a choice to sign this, or else they were just going to lose their job. So I think that's about it for the big picture hiring issues. Let's jump to handbook. So there's two questions here. Do you need one or do you want one? Do you need one? No, you don't have to have one. You definitely do want a number of key policies, anti-discrimination type policies, and at-will type policy. We'll talk about some of those. So some people are under the misimpression that you need one and you don't. Do you want one? Yes. But it's important, I think, to understand the purpose of the handbook, right? The purpose of the handbook is an opportunity for you to sell the organization and communicate information, tell your story, and provide guidelines and answer a bunch of questions. It's not going to solve everything. You're still going to get questions and you want to encourage them from employees, but you want to give them sort of the ground rules. You want to lay out the benefits, how good the benefits are. You want to sell the organization. So two pieces of advice with respect to creating a handbook. One, make sure it's customized. Do not go online and pull down a 50-page, handbook. That's not wrong, but it's just generic. Trying to not use a terrible word. Don't do it. There's nothing worse than, if we have a client who says, hey, can you review our handbook? And it's a 20-person organization and they have a 75-page handbook that they pulled down from ABC or some, company like that. It's a terrible waste of time. I'm going to charge you 10 times more to revise it than I would to just create it from scratch. Um, so that's one thing, is make sure it's customizable to what you need, and not more, not less. And two, make sure it's simple and you have a receipt. Um, so the way I look at this is, if I'm saying to somebody, what's the purpose of the handbook? I say, look, fast forward, the handbook's going to come up if somebody sues us or you fired somebody because they violated some policy. And worst case scenario, we have some trial and I put the person on the witness stand and I say, well, we have this policy that says you can't do X and you did X. The two things I can't hear from that witness are, I don't know what you're talking about, I never got it, or I don't know what it says, I can't understand it. Right. And that happens all the time, right? Because lawyers write these things, and some lawyers are incapable of speaking in plain English some of the time. Um, so my advice is always make sure you have a receipt, and and there's always Murphy's Law. You'll have receipts for every single person except for the 1 out of 500 that sued us. Well, that is what it is. But make sure you have a simple receipt just to show somehow that the person got it. And you know, my advice is always make sure a fifth grader can read it and understand it. If a fifth grader can't understand what that policy says, you need to rewrite it and make it simple. The whole purpose of it is to impart information, right? So there's no tricks here. We're trying to make sure that people who read it understand exactly what it says. Um, and again, we do a ton of handbooks, and it's always it's in some ways frustrating, just because we don't want to spend your money needlessly. But we do end up being in situations a lot of times where, look, I'm not giving you legal advice on some of these handbook policies. I'm rewriting them because it's gobbledygook and I don't understand what it says. And I don't care what it says. There's no right or wrong. It just needs to be clear. So just focus on those two things. Make sure it's customized, make sure it's simple and understandable, and you get a receipt. So let's talk about a couple policies themselves. And these are the sort of the must-haves. If I was doing a simple set of policies for somebody that was even a small organization, you'd say, look, almost no laws apply to you if you only have a handful of people. So there's not a lot of needs in there. There's things we want. But these are things I would include every time, right? You want to make clear that the handbook's not a contract. There's law all over on that. It's just a set of guidelines. It's sort of rules. We can change it anytime we want. It's not something that anybody can point to and say, hi, you have to do this. You want to make sure you have the employment at will statement in there, that just simply says, look, no matter what anybody else says, you're employed at will. We want to make that clear. You don't have a contract. You don't have a guarantee of benefits. You want your anti-discrimination policies in there. Again, they don't have to be that complicated. But there's sort of three. There's anti-discrimination, anti-harassment, anti-retaliation. They're all related. Harassment is just a form of discrimination. The key there is, again, if somebody, you don't want anybody to get in a position where they're suing you or complaining about sexual harassment or some other harassment, and saying, I had no idea what else I could do. You want to say, well, wait a minute, we have a policy. The policy explains that we'll never retaliate against you. We're encouraging you to come forward. The key to that policy is that it says, if you have any problem, here are 2 or 3 people to call. Here are their names, here are their phone numbers. There's one man, there's one woman, there may be some outside. There's no way that you can say, well, I couldn't complain because the person who was harassing me was the person you told me to talk to, right? Give them multiple options. You want to encourage, in some ways, you want to encourage people to complain. I hate to say that because HR people are like, that's the last thing we need, but you'll solve a lot of problems if people complain and you can be empathetic and fix, what the issue is before it gets out of control. I feel like if there are, if I have 10 discrimination lawsuits, 8 of them are probably not somebody who's actually been discriminated against. It's somebody who's been mistreated and is upset and is just pissed, and probably rightfully so. And it's lack of communication and it's poor management that led to where it didn't have to go. You want to lay out exempt and non-exempt status. We were when we first planned, and I talked to Robin and Nancy, we were going to talk about the fact that the salary test for exemptions is going astronomically up from 35 to 44 to $59,000. I think we all know that that's not happening anytime soon. So we can talk about it, but there's not a lot to talk about. I think what will happen is this is exactly what happened the last time Trump was elected, almost to the day. Um, the predecessor put in jumps. The Texas court came in at the last second and blew them up. The last time the Trump administration came back and increased the number for the salary test, just didn't increase it as dramatically. My guess would be we'll see something like that happen down the road. The number is now $35,000, which is more palatable than the ridiculous 24,000 or whatever it was before. But we'll see where that goes. But there's not a ton to talk about there because it was blown up, right? Benefits, lay out the benefits. Think about whether you want to have a vacation and a sick time policy versus having just a sort of wraparound PTO policy. Some employers now find it just easier than having 2 days of personal leave and 2 weeks of vacation and 5 days of sick leave to just say, we're just going to give you 20 days and do whatever you want. You don't even have to tell us why you're not going to be around. It's just, a million times more easy administratively. And, the only downside really is there's a little downside because people can come and go as they please a little bit more, but not much. And the only other risk of that type of PTO policy is when the person leaves, you have to pay out whatever is accrued. But you'd have to do that anyway. The only difference if you split them up, you don't have to pay out sick leave. But again, it's penny wise and pound foolish to me in some ways, right? If somebody leaves in the middle of the year and they were accruing sick time, it's only typically 40 hours, and you're halfway through the years, we're probably talking 10 hours, 2 days or something like that. So, but either way is fine. I would put holidays in there, make sure FMLA and anti-harassment are the two almost requirements. Nothing else is quote unquote required. If you have 50 employees, if FMLA applies, then you need to have your FMLA policy in there. You should have leaves of absence in there. You should have other benefits like retirement, 401k, any short or long-term disability. In terms of conduct, this is another question to decide upon. Do you want to have a step discipline policy? Some employers want to lay out, here are our general conduct rules, and we're going to have step discipline. Step 1 is a verbal warning, step 2 is a written warning, maybe step 3 is a final warning or a PIP, and step 4 is termination. Think about that. If you have a lot of those type of conduct issues, if you have a lot of employees, you need to treat everybody the same and kind of walk them down the plank, so to speak. That makes sense, but you have to follow it. There has to be some muscle memory there. The worst thing that can happen when you have an employee handbook is to not follow the handbook, right? So anytime I look at a handbook, if I look at step discipline, I always have the same question, which is, do you guys follow this every single time? If you don't, get rid of it. Just do the discipline as you deem appropriate. Every situation is different. Obviously, if you have a step discipline policy, the key to it, the first thing I target on is there a sentence in there that says we reserve the right to skip every step anytime we want, right? So we're not locked into it, because invariably you won't follow it to the letter every time. And I wouldn't even have one if you're a smaller organization. But it's something to consider. A lot of companies like to do it. It's always a little bit of a red flag to me. Like, it's great, only if you use it, only if you need it. So some other policies to talk about. Remote work. If we were pre-COVID, we wouldn't be talking about this, but now we are, right? So remote work is fine. I suspect a lot of you use remote work here and there. There are sort of two things I think that are important to keep in mind. One, everybody got a pass during COVID for this, but not really any longer, is there may be what we call cross-border issues. Simple idea that we're a Rhode Island organization, we allow remote work. We have a couple employees who work 3 days a week remotely, and my question will be, where do they work? Well, they work here, they work 3 days remotely. And I'll say, well, where do they live? They live in Massachusetts. So now you have a couple of employees who work in Massachusetts, right? They're 3 days a week in Massachusetts. Every Massachusetts law that applies to typical employees working in Massachusetts applies. It may not matter, but it might, right? Paid family medical leave is going to apply if Massachusetts is somebody's primary place of work. If an employee in Rhode Island is working 3 days a week at their house, their primary place of work is Massachusetts, 60% of the time. Similarly, unemployment may apply in Massachusetts. Obviously, taxes should be taken out for Massachusetts. Usually the payroll companies are pretty adept at doing that, but it's just a word of caution. We have, 10 years ago, I was practicing in Massachusetts and Rhode Island. Now I'm practicing in 25 different states because we have we have companies that have 50 employees and 35 of them are in Rhode Island and 15 of them are scattered around the country in onesies and twosies. But they are definitely working in other states. They are definitely subject to all of those other states' laws and those states' holidays and those states' sick leave issues. And maybe it never comes up. I mean, you got to be practical, and we do this with companies when we talk about, I'm working on somebody's handbook right now, right? That is let's get the core handbook in place so we have everything buttoned up, and then let's talk about your employees in different places. If you've got 3 or 4 people in New Jersey, we need a state supplement to deal with those laws. If you've got one person sitting in Texas, maybe we don't need to spend the time to do a handbook supplement for one person in Texas, knowing that Texas has almost no laws that benefit employees whatsoever. But you do have to kind of think about that just to do a little bit of a cost benefit. The other part of remote work is just make sure it's flexible. You want to make sure you reserve the right to look at the workspace if you need to, if you make sure you're agreeing or not agreeing to, I'm not paying for your desk, I'm not paying for your electrical, I'm not paying for your telephone bill, I'm not paying for your heat. It usually is not that big of a problem because people are so adept and used to it right now. But keep those in mind. Remote work is not as sort of simple as it used to be, which was people work at home 1 or 2 days a week and we don't notice it. For privacy, privacy is easy. It's one of those, hey, it's an invasion of privacy. Well, it's kind of like the First Amendment. You have no right at work to that, right? People have a reasonable expectation of privacy. And so if you ask me, well, can I look at their locker? Can I look through their desks? Can I monitor their internet? It's all on our system. My answer is going to be, the legal answer is people have a reasonable expectation to privacy. So I would say, no, you don't have the right to rummage through their desk because I would reasonably expect that you're not going to open the drawers of my desk. I can solve that problem in the handbook by having a privacy statement that says, in order to keep everybody safe and happy, we reserve the right to rummage through your desk and to open your locker, and we will monitor your email and anything that goes across our servers or on our systems. So, with that statement, you've now changed sort of the dynamic, right? The person, you can say, you have absolutely no reasonable expectation of privacy in your desk or your locker or your internet or your email, because we told you point blank, we're going to look at it and we have the absolute right to do that. So I would always do that, especially with respect to internet usage. mean, that's the main reason to have sort of a internet usage policy, is just to say, look, we're not going to go crazy here, but we will monitor email. We do reserve the right to look at everything that goes across our servers. We are going to double check to see if you're on Amazon 6 hours a day. And so when we come and ask you about it, don't say, well, that's an invasion of privacy, because that's the last thing we want to hear. And then the receipt, is the last thing. I think I mentioned that is, and we usually use a simple template that will just say, on this day, I received a copy of the handbook. Again, it's not a contract. So a mistake a lot of employers make is they include a statement in there to say, I agree to abide by all the policies. No, I'll always cross that out, saying we don't want it to be a contract. We're not asking them to agree to abide by anything. It's not an agreement. We just want to acknowledge that they've seen it, that we gave it to them, that they understand it, that they will ask us any questions. And so if they have a question, they'll come to us so they can't complain later. We'll want to re-acknowledge that it's not a contract. We'll want to re-acknowledge that I understand I'm an employee at will, and then have them sign and date it. Simple as that. We thought we'd touch on independent contractors, because that does seem to be a nonprofit issue. I think, just depending on the organization, and it's it's kind of related to the handbook, right? Do we have a handbook for employees? What about non-employees? And so there are different tests. It gets a little bit confusing, unfortunately, in terms of when somebody is classified correctly as an independent contractor or a employee. And you'll hear that once in a while, the misclassification claim. There's two types of misclassification claims. There's, you misclassified employees as independent contractors, or completely different, you misclassified non-exempt employees as exempt employees. So talking about the first one here, the default is everybody's an employee. So, you sort of need to understand that the starting point is the law is going to assume somebody doing work for you is an employee. And so the ball is in your court to prove otherwise. And, unfortunately, like a lot of things, there is federal law and there is state law. State law is different. I think people are usually familiar with, like, Massachusetts has the famous ABC test, they call it. A number of other states have that. And when you hear that, the difficulty of that ABC test is one of the B in the ABC is that the person has to be doing work outside the course of the company's business. That's where everybody fails, right? Where if I'm a law firm and we have too much work to do, and so I'm going to outsource some work to a lawyer who may be a stay-at-home dad, that work is not outside the course of our business, right? So that person is almost impossible to try to classify him or her as an independent contractor under that test. If you're not in Massachusetts, Rhode Island, and federal law looks at, I gave you a list of some of the different factors that they'll look at. There's an IRS test that has 20 factors. It's 20 variations of the same thing. So it is a little bit confusing, but at the end of the day, it really boils down to control. To what extent does the company control what this person is doing versus the person's doing it on their own. So you can think of, make me a statue. Come to my office, you're going to work 9 to 5. I'm going to pay you by the hour. I'm going to give you the tools. I'm going to give you directions. I'm going to tell you what it's going to look like, how to do it. You can take an hour for lunch and you're going to be working for me 40 hours a week. That person's looking pretty much like an employee, right? Versus I'm going to pay you to make a statue. You do it on your own. It's up to you to bear the expenses. You can do it however, I want it to look exactly like this. How you get there is up to you. You're going to use your own tools. I'm not paying you by the hour. I'm paying you by the job. I'll pay you $5,000. I need it in a month. And I don't care if you do it over the weekend or if you have 16 other jobs, you do whatever you want, right? That person definitely is going to roll out as an independent um, contractor. So, um, again, there are a lot of different things that come into play, but I wanted to mention this just because of my experience working with nonprofits. I've seen for whatever reason in your industry, there seems to be a lot more misclassification issues. You're less likely to pull people in for good reason, usually as employees and have them as independent contractors. It's just a risk factor that I think people should think about. And there are two risks there, right? The risk is if the person was supposed to be an employee, they didn't get benefits, they may not have gotten overtime, they have a claim against you for those things. So, you may look at it and say, we don't give benefits anyway. The person worked 20 hours a week. They wouldn't have gotten any benefits. They're never going to work overtime. Probably not a big risk. The other risk is just the IRS risk. You get audited. Everybody internally is happy. The independent contractors are happy. The IRS comes in and says, we really don't care if you're happy or not. You should have been taking out taxes, and so we're going to ding you. It's the same with exempt and non-exempt. I've had those situations on DOL audits where they'll come in and, the boss's secretary is exempt and his job is clearly non-exempt, but he doesn't care. He's happy as a clam. He doesn't want it otherwise. Department of Labor is going to say the same thing. We don't really care what you want. You're definitely non-exempt. You're definitely entitled to overtime. You definitely mispaid this person, and we're going to force you to fix it. Let's jump to the fun stuff. We've got time. I think we're right on time. Termination. So hopefully it doesn't happen a lot, but it happens, right? Every once in a while, somebody's got to go for good reason or not. So first piece of advice, this is easy to say, it's almost impossible. Try not to let it be a surprise, right? I can probably count on one hand the number of times in my life where I've been involved in firing somebody that the person didn't claim it was a complete surprise. But you should do everything you can to make sure the person does not feel like you're just, cutting their legs off, that you gave them ample warning, you gave them a PIP, if it's appropriate. There are emails, there are a lot of different situations, but again, to avoid the angst, to avoid somebody feeling like they've been treated inappropriately, which sometimes can lead to legal claims, lead them to go to a lawyer for whatever reason to think they've got some type of a claim. They don't know what it is. The lawyer will usually create one for them. That's what we're trying to avoid, right? I think 90% of my job I usually tell people 90% of my job is to slit my own throat, because we make a lot of money if you guys get sued. And what we're trying to avoid with all of this is we don't want you to get sued. We'd rather you bend over backwards and, make it impossible for somebody to sue you by having the right policies and procedures in place and treating everybody in a way that is not going to create lawsuits, because lawsuits are just going to be, super expensive, even if you win. I'm sorry, a PIP, a performance improvement plan, right? So it's sort of a warning. You have somebody who's not doing the job. This is the typical situation, right? Which is the person's not doing a great job. They're not terrible. You're not going to, you don't want to kill them. They haven't done anything that's so outrageous that you're going to fire them on the spot. They're just not performing as well as you'd like, and they don't seem to be getting it. And they probably think they're doing well, and they've screwed a few things up, but everybody screws a few things up. And in the meantime, you're thinking the next thing they screwed up, I'm going to fire them. And so you go to fire them. They're like, what are you talking about? Like, I've only screwed like 3 things up this year. And you're thinking, no, it's much worse than that. And there's always a disconnect in the communication there. So the purpose of the performance improvement plan is to say, hey, let's put in writing, it doesn't have to be mean, in a nice way. Hey, you're trying, we appreciate it, you're a good employee, but you're falling down on the job in these areas. Here's specifically what you're doing wrong, and here's the specific improvements we need to see, and here's the specific time frame we need to see it in, right? In other words, it's a 60-day PIP. We need you to turn things around in the next 60 days, and we're going to see you in 60 days. And if things haven't turned around, we may have to talk about an exit strategy. And so it's sort of like a smart plan. It's sort of time constrained and saying, here's exactly what we need. And so you're painting a picture that if things don't work out, the person sort of realizes it. When you do get to a point where it's just inevitable and you have to do the termination, the big mistake I see people make is this idea that you don't want to give a reason for some reason. A lot of companies, again, it's what leads to lawsuits, right? Which is, I have one right now where, and despite my telling the client what to do, we got a lawyer's letter, and the lawyer's letter said, she was great, she did a great job, and when she pressed them at the termination meeting for why she was being fired, they refused to give her a reason. And I'm like, that's the worst thing you can possibly do, because nothing's going to, irk the employee more than just shrugging your shoulders and saying, well, you're an employee at will, we don't have to give you a reason, right? Like, legally, that's true. You can fire them for no reason, but put yourself in the employee's place, right? Which is, well, it's not economics. They gave me no reason. So the reason they didn't tell me is it must be because, I'm over 40. That's the only reason I can think of, because they wouldn't give me a reason. So yes, you don't have to have a reason, but you can't fire somebody. At will means, you don't have to have a reason to fire the person. You still can't fire the person for discriminatory reasons, right? And so you've got to, hit that. I always say, hit that middle ground of saying, give them practice what the reason is. You don't want to throw them under the bus necessarily, but you want to give them the reason, be honest with them. And that does not mean it's a negotiation, right? So the first step is, we're going to have to let you go. We're sorry things didn't work out. We just didn't feel, whatever it is. Say more than it's just not a good fit. I give you some examples, but the performance has to be laid out so they understand it. If they want to fight back, you can answer one question, but then I would sort of cut off the discussion just to say, look, this is not a negotiation, right? We've given you our reasons. We're not going to change our mind. Unfortunately, your time has come to an end, and today's your last day, right? So we're not going to tell you nothing, which makes it seem like we're hiding something. We're going to give you a simple reason, but we're not going to get into a negotiation. You're not going to save your job. Like we've made that decision. That's where the termination letter comes in. Anybody that's been fired, again, once you give them the reason, you say they're fired, oftentimes they're not hearing anything else you're saying anyway. And so they'll walk away forgetting half of what you said, just because it's a shocking, terrible thing, no matter how you slice it. So I would typically encourage people to say, when you terminate them, immediately tell them, look, your healthcare is covered for the rest of the month. You can go on Cobra. We'll send you information about that. We're going to continue to pay you for the rest of the week or 2 weeks or whatever it is. If you're going to give them severance, say we're going to give you an opportunity to have a severance agreement that'll pay you another 3 weeks pay or whatever, and then give them that paperwork. My experience at least has been, once they hear termination, all they think about is, when do I lose health care and when do I lose my paycheck? So typically, you pay for health care at the beginning of the month. Most good employers will say it's already paid for. So if we fire you anytime during the month, your health care is covered for the rest of the month, and tell them when their pay is going to end, just to give them a little bit of comfort there. Severance, people usually ask about what should I do with severance, or what's required. There's no requirement, unless somebody has a contract, of course. There is no requirement that anybody receive severance. As to how much severance people typically get. There's no right or wrong answer to that, unfortunately. Some bigger companies have systems, where they make it easy on themselves to say the way we avoid negotiating severance with anybody is we just have a program in place where we pay everybody the same thing. Everybody gets 2 weeks. You get another week for every year you've been there. Nobody gets more than 16 weeks. I'm making up numbers a little bit. Um, that's one way to do it. At this time of year, it's December. Everybody who's being fired now will almost always be paid through the end of the year. It just seems like that's what happens during the holidays. But there's no right or wrong to that. It's very person by person. I usually ask them, is the person litigious? Does the person have a legal claim? How do you typically treat other people in this situation? And we kind of work through it that way. You typically want to get a release. My general advice to employers is don't give any severance unless you're getting a general release of claims. You don't want to give somebody a month severance and have them sue you for something afterwards because you're not getting that money back. So typically have them sign a separation agreement, and that'll include them waiving any legal claim they may have. Some people get scared at that, like, is that going to send a message that they have a legal claim? And I say, no, not really. I mean, if they take it to a lawyer, they'll tell them it's typical, and you can say, I'm going to have you sign a general release because my lawyer says nobody gets severance without signing a general release. Blame your lawyer for it. I don't think it's that problematic. So that's typically how severance works, but you want to make sure you have them sign some sort of general release. If the person is over 40 years old, there are a bunch of bells and whistles that have to be in there. For wage and hour, there are some bells and whistles that have to be in there. Don't create one off the internet. Go talk to a lawyer. Make sure you have a severance agreement that's actually going to be enforceable. It's not complicated, but there are specific sentences that have to be in there. If the stupid sentences aren't in there, it's invalid. Like it is that direct. And then unemployment, last but least, we get questions on more often than not, companies wanting to fight unemployment, because the person was a bad employee. You're not going to win that fight. Employment is set up to pay everybody who loses their job for any reason employment because they've been paying into unemployment for years. So unless somebody is being fired for misconduct, which is a pretty high standard, not that they were a terrible employee, but that they stole money or did something awful, more often than not, they are going to qualify for unemployment benefits. So you can object to it and go to a hearing and fight it, but you will almost always lose that fight. It's maybe a little bit of an overstatement, but it really has to be something that's misconduct. If the person quit, they're not going to get unemployment. That's the other thing that comes up. Some people quit and then ask for unemployment. They're never going to get it. So unless they quit for good reason, which means, again, they had no choice, they were being harassed or something like that, it should be a pretty high standard. But more often than not, if you have 10 unemployment claims and you should win and lose 5, you'll probably lose 8. You'll lose ones you should win more than you'll win the ones you should lose, because the system is geared to trying to bend over backwards to pay people. So I think that's it with termination, and I think we're butting right up against the hour. So if anybody has questions, I'm happy to answer them. You guys have my email. I'm around today. If somebody thinks about a question later and you want to shoot me an email, I'll answer it. No charge. Don't worry about that.
Can you just
There was a lot of stuff in a short amount of time, hopefully somewhat useful.
Can you just do a 1-sentence explanation of exempt versus non-exempt for folks?
Yeah, somebody is exempt means that they are exempt from the law requiring people to be paid overtime if they work more than 40 hours. So exempt people, sometimes they call them salaried. It's not exactly true, but so if you're exempt from overtime. I can work you 80 hours a week for a salary. I don't have to pay you anything extra. If you're non-exempt, you're not exempt from overtime. If you work more than 40 hours a week, you're entitled to time and a half. And so for somebody, everybody is assumed to be non-exempt. Everybody's entitled to overtime if they work more than 40 hours. The whole purpose of that law from like 1938 was we don't want people working more than 40 hours. So if you're going to work in more than 40, we want to punish the employers and make you pay extra to encourage you to hire more people at 40 hours and less people working more. So you're assumed non-exempt. You can be exempt and you don't get overtime. You have to meet two tests. The first test is the salary test that we talked about. So step one is you have to be paid a salary right now of at least 35,000 and change. If you're paid less than $35,000, it's impossible for you to be exempt. And if you pass the salary test, then you have to pass what they call a duties test. And so you have to perform duties that exempt you. The duties tests there's three big ones. There's more than three, but the three big ones are the, professional doctors and lawyers perform duties. They have advanced degrees, they're exempt. What they call executive, which is really what we call the manager exemption. So if I'm managing at least two people that report to me, they both two full-time people, and that's my primary job is managing, and I passed a salary test, I can be exempt. So typical managers, supervisors are salaried exempt for that reason. And then the other is the administrative exemption, which is all people you would think the head of human resources, the controller, the CFO, they may not have people reporting to them, but they perform duties at a level and they have a salary at a level that exempt them. They say you've got to perform duties and exercise independent judgment and discretions on matters of significance. So there are a lot of layers to that and bullet points on what that really means, but that's how you funnel somebody into an exemption. Does that make sense?
Yeah, and there's two quick questions in the chat. One is there a set number of hours or numbers up to that constitutes as a part-time employee in Rhode Island?
No, there is only for health insurance. So there's nothing part-time wise. So for example, if you were a company, you can say it's sort of arbitrary to say, look, we provide benefits to all full-time employees and you get holidays paid, you get vacation, you get all this great stuff. If you're a part-time employee, you get nothing. And then you can say, we define part-time as anybody working less than 30 hours, anybody working less than 20 hours. You can set that. The only exception is for healthcare by the Affordable Care Act. Everybody who works 30 hours is full-time for purposes of healthcare. Does that make sense? So you could say, hey, for all you guys who are part-time, and we consider part-time, anybody who works less than 40 hours is part-time, which is extremely aggressive, but you can say, fine. So all you guys that work part-time 39 hours or less get nothing. The one exception is we have to offer you health care because federal law says we have to offer everybody who works more than 30 health care. Otherwise, there's no requirement as to what the definition of part-time is. It's usually less than 20. That's how most employers look at it.
And then the last question is, when does unemployment start? At the time of separation or when paid compensation ends?
Yeah, that's a great question. So it gets a little bit nuanced. It's the answer in Rhode Island is when paid compensation ends. The answer may be different in Massachusetts. So, in Rhode Island, if I were to give you severance of, let's say, 3 months, you're not going to get unemployment during the 3 months you're collecting severance.
Great.
If I was in Massachusetts and I gave you 3 months of severance and you signed a general release, then the severance doesn't count because it's not compensation, it's money that you got for the release. And Massachusetts employees actually would be allowed to collect unemployment during that 3-month period and severance. You can't do that in Rhode Island.
Great, thank you.
And even if you were to give somebody severance of a lump sum, like to avoid giving them 12 weeks of pay, you're just going to give them 12 weeks of pay in a lump sum. The DLT is still going to look at the lump sum divided by 12 and run it out and say, we're still not covering you for the first 3 months. So you can't sort of game the system on that attempt either.
Robin, you can go ahead and do the wrap up. I was just reading, that's all that was in the chat, so.
Great.
Well, thank you so much for joining us, everyone. You will be receiving an email from me shortly. It'll have Michael's contact information as well as a short survey to let us know how he did. And thank you for joining us.
Thank you, Michael. That was awesome.
Thank you, guys. Thanks for having me.
Thank
It
you.
was a pleasure.
Thank you.